where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by.
I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me.
Are that the daughter allegedly said that my client penetrated her every single day. Good afternoon, Your Honor. Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's the date time set for our second probable cause conference. We had adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam, assuming that they in fact were uploaded today as stated by the prosecutor.
For clarification purposes, I have confirmation from the detective, the officer in charge, that they have just as of today been shared and made available on evidence.com. I've relayed that information to the proper individual in our office. I would expect that those will still be shared with counsel before the day is over. But just to be clear for the record.
All right. And if those are done, then discovery is complete.
Yes.
Yes.
Don't like to do it this way, but I get what you're saying, that it's there.
Understood, Your Honor. Thank you.
If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right. But that's what we try to give people time at PCC to get all that stuff straight and not set something and then have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the 28th
28th of
January.
what time?
9 a.m.
Oh, I'm not available at all that day. I have a 9 a.m. exam and a 12:30 sentencing.
February 4th
Checking.
or February 11th.
What time? February 4th, 9 a.m.
No, you're all at 9 a.m.
February 11th. February 11th is good.
Preliminary examination in person, February 11th, 2025, 9 a.m. before. Am I ahead on that list? Okay. Before Judge Valvo.
I didn't hear the name. What name?
Valvo,
Thank you.
bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. The family can stay with a friend in a separate location, but since the incident that the 2 children of my client have been taken away, even though CPS has not filed any the case has been closed. There's no issues. The children are staying with grandparents, and this has been going on since early December.
Your Honor, people continue to object to that. Again, as I indicated the last time you were here with the same request, I get that. I really do. I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose. That being said, our charged victim, her first trial best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by.
This whole situation feels really messy. The daughter didn't say anything in her own interview, but now we're hearing that the victim says the daughter told her something totally different. It's all based on what someone else is saying, not what the daughter actually said herself. It's hard to tell what's real and what might have gotten mixed up. Without something clear, like evidence or the daughter's own words, it feels like they're guessing. But guesses in a case this serious can ruin lives. The whole thing just feels shaky, like it could fall apart at any moment. Let's see if she brings any proof later on.
There's some. as well. Well, I am concerned, I'm not willing or able to agree to change those bond conditions. Understanding, obviously, ultimately it's up to the court, but I am concerned for the safety of any minor child.
And I'm quite frankly, counsel, I'm in the same position I was the last time, I think, that, I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its bond conditions.
Can I just make a record on one matter?
Sure.
Thank you so much. My client's daughter, Lila, who the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There's no indication of any sexual assault. She was also, as stated, interviewed in a forensic setting and did not make any disclosures. We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
Judge, as I indicated last time, same record was made then, same arguments were made then.
I know.
Certainly the court has been doing this as long as I have been doing this. There aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about type of sexual assault. It's all about those areas of our bodies being fast healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child has been sexually assaulted.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
It would not necessarily be. Penetration can be a whole lot of things with a whole lot of things.
Yes. And again, I know you made your record, but I'm still at this point going to deny that. Judge Valvo, after the dam happens, may feel differently, and certainly you can bring that before her. But at this time, I'm going to deny the request. Bond will continue.
Thank you very much.
Thank you.
Thank you.